Thank you, Riya. Ma Saraswati la Vandan. Government Law College, Mumbai, as we all know, is one of the oldest law college established in the year 1855. This college has given freedom fighters, social workers, social reformers, social activists, judges, eminent lawyers, and very good teachers to the society. This college has witnessed making of the Constitution. As Riya highlighted, with a view to celebrate completion of 75 years to the establishment of Constituent Assembly, our college has decided to conduct 75 different academic activities in between 15th August 2021 to 26 January 2022. The different academic activities comprises of the national webinars, national quiz competition, national level guest lecture series, street plays, legal awareness programs based on the Indian Constitution. Today, we are happy to have Dr. Seema Singh Madam, Campus Law Center from Delhi University, Delhi, with us. Dr. Seema is an academician, scholarly person, and do have deep study on Constitution of India. Today, she is going to discuss about history of preamble and contemporary debates. Madam, from bottom of my heart and on behalf of Government Law College, I welcome you. At this point of series of academic activities, I appreciate the efforts taken by coordinator, Dr. Panchabai sir, all the teaching and non-teaching staff, the technical team, and most importantly, my students. They have given wonderful response to us. Similarly, I also appreciate the presence of many academicians from different law colleges throughout Bharat. I welcome you all again. Thank you.
Thank you so much, ma'am. I would now like to introduce our speaker and chief guest for today, Dr. Seema Singh. She is an academician with an experience of more than 12 years in teaching students of LLB, LLM, and PhD courses. She has an experience in taking courses on comparative constitutional law, international economic law, media law, economic offenses, law of evidence, administrative law, and criminal law. She has also authored and edited many books like Law of Spirituality, Exploring the Bond, Reflections on Ancient Indian Jurisprudence in the Current Social and Judicial Setup, Nagarikta Sanshodhan Adhiniyam, Tathya Evam Satya, Ek Bodhik Vimarsh. Not only this, but there are more than 16 articles published in law journals and more than 25 published articles in different magazines and newspapers with the name Dr. Seema Singh. She has participated as a resource person of the sessions in more than 80 programs. She has also been a panelist on socio-political legal issues and frequently participates on different news channels. She is an activist and a part of many public interest litigations like PIL against WhatsApp, Netflix, and farmers' suicide. We are delighted and extremely honored to have you here with us, ma'am. We are extremely excited to hear your thoughts on the topic History of the Preamble and Contemporary Debate. Without further ado, I would like to invite Professor Dr. Seema Singh to kindly begin the lecture.
Thank you so much, Riya, for introducing me. And I'm extremely thankful once again to Principal Dr. Mrs. Asmita Vaidya and all the respected faculty members who are present here. And I'm also very grateful to all the students who are especially here just to listen me. So it's a privilege for me to share my ideas over such a relevant topic to all of you. And I believe that it is going to be a quite interesting session. And before starting, I just wanted to share my screen with the PPT. Is it visible to all of you?
Yes, ma'am.
Okay. So the topic for lecture is today's discussion is history of the preamble and contemporary debates. And I will especially mention the meaning of the contemporary debates because now a lots of discussion is going on, especially once the Chief Justice of India, Justice Ramanna and Justice Nazir is talking about the Indianization of the legal system. And we can see that, the different kind of opinions are floating across the India, and many people are also criticizing the idea of Indianization. So basically, what is the meaning of Indianization? And once we are going to study the Constitution of India, or once we are going to read the Constitution India, whether the Constitution and the Indianization, they both can be separated, and what is the actual meaning of the Indianization of law. I will slightly try to connect both the things in this presentation also. So, this is the entire preamble. It begins from "We the people of India," and you all are aware about the content of this preamble. This preamble is very much important. And I would like to draw your attention on two very important points. The first important point is it begins from sovereign and it comes to an end with the term fraternity. So remember, in between sovereignty and fraternity, there are so many things, so many rights, so many declarations, so many goals. But yes, it seems that the sovereignty and fraternity, they both are the starting and the beginning point and the end point, and between these two, all the rights, everything lies. So you know what, most of the time, what is the problem? Once we are going to talk about the fundamental rights, we are more concerned about liberty, about the idea of equality, about the idea of justice. But the first thing which has been compromised a lot, that is the fraternity. And that's why once you read the Constituent Assembly debate, there too, Dr. Ambedkar has very clearly mentioned that fraternity should not be compromised in the name of equality or liberty. So, this fraternity means there should be a very cordial relationship among all the classes, among all the masses, and in the name of the liberty and in the name of equality, any kind of enmity or any kind of discrimination which is not positive, that should not be encouraged. So this is something which is very much important, that the sovereignty of this country can never be compromised, and simultaneously the fraternity of this country can also be not compromised in any case. Now, the next important point is the Constitution of India. The Constitution of India is a Suprema Lex. We all are aware about this thing. And this is a fundamental document which is basically going to talk about the structure, procedure, power, and duties of the government institutions, and sets out fundamental rights, directive principle, and the duties of the citizen. So, there is a lots of discussion because I am a teacher of the constitutional law. So being the teacher and being the student of the constitutional law, once a debate which is prevalent normally, in all the domains, that what is the purpose and what is the meaning of the Constitution. So, the purpose of the entire system which has been created through the Constitution, that is basically to protect the idea of justice. That is basically to deliver the justice. What is the meaning of justice? That is again something which is a very debatable issue, because once we are going to talk about justice, normally it seems that we are going to talk about the judicial pronouncement. But remember, once we are going to talk about justice, justice in itself is a very broad concept, and it includes social, economic, and political, all sorts of justice. And it is not only the responsibility of the government of India, but it is the responsibility of each of us, because this Constitution belongs to us. We are the sovereign under this Constitution because it begins from the term "We the people of India." Again, very important. Next very important aspect is most of us are not aware, because once we are going to talk about this thing, the Indianization. certain things are being targeted, that the Indian philosophy is old or it is not contemporary, or this is, some people also say that you are going to promote a particular community and all. But here I wanted to draw your attention on a point which is very important. As we enter the Supreme Court, we see a motto, Yato Dharmas Tato Jaya. Furthermore, as one enters the portal of the parliament, again you will get one thing, and that is known as Satyameva Jayate, which is the, which is mentioned on the Dharma Chakra. So once you are going to combine whatever is mentioned on the as a motto of the Supreme Court and whatever is mentioned in the parliament, the ultimate purpose of both is to protect Dharma. The ultimate purpose of to protect both is to protect Satya. Most of you are perhaps not aware what is the meaning of Yato Dharmas Tato Jaya. Where there is a dharma, there will be a victory. But it kahan se liya gaya hai? Most of us are not aware. So I just wanted to tell you, because once we are talking about the Indianization, the meaning of Indianization is the philosophy of India. This term Yato Dharma se Tato Jaya, it has been adopted from Mahabharata. And when this statement was quoted, when Duryodhana was going to fight against the Pandavas, every time whenever he used to go to his mother to get her blessings, that give me blessing that I could get the victory, his mother Gandhari never blessed her with the blessings of receiving victory. Every time whenever Duryodhana went to her, every time she said Yato Dharma se Tato Jaya, means wherever there is a dharma, there will be a victory. So this is the height of the character of Gandhari, that she is not blessing her son because she knows that he is wrong. Every time she is saying only one thing, कि जहां पे धर्म होगा उसी की जीत होगी. So the ultimate purpose of the Supreme Court is basically to protect that dharma, and the meaning of dharma means something which is going to protect the truthfulness, the something which is going to protect the satya. So this relationship and this purpose of the constitution and the relationship between the motto of the Supreme Court and the Dharma Chakra, Satyameva Jayate, that can be established, and this is something which is very, very important. Now the next important thing is, most of us know about the Constituent Assembly, but there are certain points which I personally believe are very much important to be discussed. Like, once we are going to talk about the Constituent Assembly, it was set up as a result of negotiations between the leaders of the Indian independence movement and the British government. The Constituent Assembly was elected indirectly by the people of the Provincial Legislative Assembly. Once we talk about the Constituent Assembly, perhaps a few things are not known to most of us. Like, this Constituent Assembly was the result of the cabinet mission. And Mahatma Gandhi was never in the favor of the Constituent Assembly. Why he was not in the favor? Because this Constituent Assembly was created with a precondition. The precondition which was put by the Britishers. And what was the condition? Firstly, India will get divided, and then India will get independence. So what Mahatma Gandhi always used to believe, that through this way, through this bargaining, basically the Britishers are going to involve Indians into a state where the country is going to be divided into two parts, and this is not in the interest of India. So that's why in the entire, even the Constituent Assembly debate, you will not get any discussion about the idea of Mahatma Gandhi, about the vision of Mahatma Gandhi, which he used to see about India. So what was the Bharat in the opinion of Mahatma Gandhi? It has not been discussed anywhere in the entire constitution. Only one aspect which has been accepted of Mahatma Gandhi, and that was introduced by Dr. B.R. Ambedkar, and that was Gram Panchayats. Besides that, the philosophy of Mahatma Gandhi does not get appropriate place in the Constitution of India. And I told you that he was not in the favor of the Constituent Assembly, क्योंकि उनको लगता था कि ये एक ब्रिटिशर्स की चाल है, and they are going to trap India in the name of freedom, because they are going to divide it. The Assembly approved the Constitution on November 26, 1949, celebrated as a Constitution Day, a day now commemorated as Republic Day in India. इसमें एक दूसरी important चीज ये भी है कि most of you are not aware that how the first Parliament of India was created. So remember, the Constituent Assembly itself became the first provisional Parliament of India. So all the members of the Constituent Assembly, they were also the members of first Parliament of independent India. So this is, that's why, whenever the first constitutional amendment was, proposed in the year 1951, there was a lots of debate also, because all the members of the Constituent Assembly, they were the members of the Parliament, and the assembly which gave right to property as a fundamental right, the same assembly has introduced Schedule 9 of the Indian Constitution, which in a way basically dilutes the right to property. So, this is something which is very much important to know. The another important thing is B.R. Ambedkar drafted the Constitution of India in conjunction with the requisite deliberation with the Constituent Assembly. So once you are going to read the Constituent Assembly debate, remember there was a drafting committee and there was a Constituent Assembly. So drafting committee used to propose the draft to the Constituent Assembly, and in the Constituent Assembly, the members used to discuss over the provisions of those drafts. And this was the responsibility of Dr. B.R. Ambedkar to satisfy the questions and the objections of the members of the Constituent Assembly. So that was a very important role which was played by Dr. Ambedkar, because he has to defend each and every provision of the drafting committee, but the drafting committee was going to propose to the Constituent Assembly in the form of the different provisions of the Constitution. Another important thing is, because still even several Supreme Court judges has considered it, that we consider this Constitution of India as a perfect document. But what Pandit Jawaharlal Nehru has said in the Constituent Assembly debate, and the same thing was approved by Dr. B.R. Ambedkar also, and they both have admitted that this document is not a perfect document. And why they are going to say this, the timing of the making of the Constitution is also very much important. Why they have said this? Because when the Constituent Assembly was preparing the Constitution, at the same point of time, India was divided into two parts, and at that particular point of time, lots of communal riots were going on. And the lack of people were killed, they were murdered, and the people were migrating from Pakistan to India and from India to Pakistan. So that was a situation where the law and order situation of this country was very bad, and it was a major setback for each and every Indian when they came to know that India is going to be divided. So that is a very unsettled time. The timing was not perfect, and this was also a very important reason that Mahatma Gandhi was not in the favor of this Constituent Assembly. So the people are dying, the people are killing, the people are murdered, they are moving from one country to another country, and in that very unsettled time period, Constituent Assembly is working. So we can imagine about their psychological pressure also. And that's why Pandit Jawaharlal Nehru has said that we have created a document at a very imperfect time. So this document cannot be considered as a perfect document. And this was the reason that Article 368 was put there, which prescribes procedure to amend the Constitution, so that the Constitution could be amended by the passage of time and could satisfy the need and requirement of the people. Constitution of many countries, primarily of those, it is again a very important point, because there are now few people are also demanding about the review of the Constitution. So there are certain things which are very much important. Once we read the Constitution of India, the different provision of the Indian Constitution has been adopted from some or other country. Even once you are going to appear for the entrance examination, you will get such type of questions. That directive principle of the state policy was adopted from which country, parliamentary system from which country. So one thing is very much important. All those countries who were the colony of the Britain, only their constitution was studied, only their system was studied. And that is something, which is quite unique, because constitution of many countries, primarily of those who were earlier the colony of the Britain, their provisions were picked up and discussed by the Constituent Assembly. So, the important part is all the countries who were the colony of the Britain, only their constitution was studied, and only the relevant portion from their constitution were picked up by the drafting committee and subsequently discussed in the Constituent Assembly. So that is a point on which certain people also raised objection, because one important issue was raised in Constituent Assembly debate also, and that issue is why the members of the drafting committee, they have discussed or they have studied the constitutions of the foreign country. India in itself is one of the oldest civilization, so that mechanism through which about which the Indians were very much used to, they were very much familiar. Why we are not studying our own indigenous model of government, so this is something which becomes very, very relevant. So that's why now at that particular point of time there was this objection also, that the ancient Indian model should also be discussed, and the important practices about which the Indians were already aware, they should be the part of the Indian constitution. So some people have raised these issues, but yes, obviously these things were not accepted. But now once we are going to talk about the Indianization, against those observations and those suggestions became very, very important. Now the next important thing is, what is preamble? A very important point I wanted to discuss here. Most of the time what happens, preamble is basically, it is an objective, and the Black Law Dictionary describes it in this form. The important aspect of this preamble is, preamble or objective clause you will get in case of every legislation. So what is the important, how the Indian constitution is different from the rest of the legislations? In the case of the rest of the legislation, normally firstly objective clause is created, and then the provisions are enacted. But in the case of the Constitution of India, firstly the constitution was made and preamble was made at the end. So there is a difference, So firstly we are going to make the entire constitution, and then we are going to make the preamble. But yes, according to Black Law Dictionary, the preamble means a clause at the beginning of any statute to explain the reason for its enactment, and the same thing is applicable in the case of preamble of Indian Constitution, because the preamble of the Indian Constitution is a key to open the mind of the constitution makers. But this is quite unique, that it was not created firstly, but it was created when the rest of the provisions of the constitution were already drafted. Now keywords in the preamble and meaning, it's a very lengthy process, and it will take a quite long time to discuss the meaning of each and every provision. But yes, obviously it begins from we the people of India, and they are also considered as sovereign, because sovereignty lies in the people of India as per the preamble of the Indian Constitution, and it keeps certain terms like sovereignty, socialist, secular, democratic, and republic within the domain of the preamble. Adoption of the preamble. The original preamble adopted by Constituent Assembly in 1949, and in the original constitution, there were certain terms like sovereign, democratic, republic, socialist, and sovereign term. This was not the part of the socialist, sovereign, and secular term. This was not the part of the original constitution. So the original constitution says sovereign, democratic, and republic, while the socialist and the secular term was subsequently added through the 42nd Constitutional Amendment Act 1976. That was not the part of the original constitution. Now let's come to the next slide. History of the preamble of the Indian Constitution. The ideals behind the preamble to India's constitution were laid by Pandit Jawaharlal Nehru. That is also, there is a great debate, because some says that this was proposed by Dr. Ambedkar. Some says that the preamble belongs to Mr. B.N. Rao, and some says that it belongs to Pandit Jawaharlal Nehru. But yes, obviously the credit goes to Pandit Jawaharlal Nehru, and it is believed that the ideals behind the preamble to Indian Constitution were laid down by Pandit Nehru in the form of the objective resolution, which was adopted by the Constituent Assembly on 22nd January 1947. Now, although not enforceable in court of law, this is again a very important part, because being a student, maybe you have asked this question, or you have read this question, that at several point of time, this question is asked that whether the preamble can be enforced by the court of law or not. So remember, the preamble in itself is not enforceable, but yes, this plays a very important role in interpreting the constitution. So, the Constitution of India is definitely a suprema lex, but remember, whenever you are going to interpret the constitution, that should be according to the natural law of justice. So you can say that if something is above the constitution, then that is the natural law of justice, because only by the application of the principles of natural law of justice, the constitution can be properly interpreted. So that's why once you are going to talk about the social, economic, and political justice, you can take the example of this thing, Article 21. What Article 21 says? No person shall be deprived of his life or personal liberty except according to the procedure established by law. Then subsequently, in the case of Maneka Gandhi, the Supreme Court has held that the term procedure established by law should be read as due process of law. So, once you are going to travel a journey from procedure established by law to the due process of law, the simple thing is that you are going to interpret the procedures according to the natural law of justice. So, the natural law is the most important law, because this is the first law. This is the law of the nature, and this is the standard law which never changes. Man-made laws are imperfect, and they are imperfect. And this is the reason that we keep changing or amending them. But in the case of the law of the nature, no amendment is required. So that is a permanent law, and that is the best law. That is the most superior law. So always remember, even in the interpretation of laws, we always apply the theory of the interpretation of natural law. Now, what is natural law? How we can identify it? This is something, again, which is a very debatable issue. And once you are going to, read the thinkers and, jurists, most of them will talk about natural law. But once you are going to ask them how we are going to identify what is natural law or what is the meaning of natural law, most of them will just talk about the principles of natural law of justice, Audi alteram partem, and rule against bias. But remember, how to identify the natural law, if any civilization has worked a lot on these things, then that is either India or Romans and Greeks. But Romans and Greeks, because you all are aware, we have read about the Plato and the Socrates, but subsequently they get disappears. Their entire thought, their entire idea, that disappears, and that was because of the constant, invasion of Christianity over this country, who completely destroyed these civilizations. But somehow India was still in the position to protect it. So that's why, if you want to study what is the meaning of natural law, definitely you should read the Indian philosophy. And the meaning of Indianization means reading Indian philosophy. And if you are going to read Indian philosophy, specifically, you are going to understand that how you are going to identify the law of the nature. If any time Madam Vaidya gave me any opportunity, then definitely I will try to discuss that, how to identify that what is the law of the nature. But as of now, let's come to the next slide. History of the preamble to Indian Constitution, resolution and discussion. Although not enforceable in court, the preamble states objective of the Constitution and act as an aid during interpretation of articles when language is found ambiguous. As I told you in the beginning of my address, that the Constitution begins with sovereignty and it ends with fraternities, and in between these two, every right lies. So whenever there is a confusion regarding the interpretation of a particular clause, or there is some ambiguity, preamble always plays a very important role. But personally, I have observed this thing, that even while interpreting the Constitution, many times judiciary puts a lots of emphasis on a particular term. Like for some time for the judiciary, liberty is very much important. Sometimes the equality is very much important. But while interpreting these things, many times, you will realize that they are going to compromise with the idea of sovereignty and fraternity while interpreting the Constitution. That's why I'm repeating again and again that in the preamble, each and every word should receive equal importance. That is very, very important. Constituent Assembly meeting on 9 December 1946 in Constitution Hall, which is now known as the Central Hall of Parliament House. So the first meeting of the Constituent Assembly. For the first time, the Constituent Assembly met on 9th December 1946 in the Central Hall of Parliament House. So if at any point of time, if you people are visiting Delhi, so please go and visit the Central Hall of Parliament House, which is still obviously there. The Constitution of India was adopted on 26 November 1949. The honorable member appended their signature to it on January 26, 1950. So, you know, this 25th, 1950. So, you know, this date is very much important. And once you are, I will request you, and I will also request Professor Vaidya that kindly keep a copy of the original Constitution in your library. Most of us have never seen, even I have found, because I keep organizing several type of conferences also, even the judges have not seen the original copy of the Constitution. And the original copy, you know, the texture, the nature of the original Constitution is very much different from the Constitution which we read. So unless and until you are able to, you know, see the original Constitution, you cannot connect the content and philosophy. So, you know, the connecting link you can establish only once you are going to once you are going to see the original Constitution. So I will request you, ma'am, please keep one original copy of the Constitution in your library. Now debates on the preamble. Hasrat Mohani proposed that India, you know, when the Constituent Assembly was going to make the Constitution, there was a lots of debate that what should be the starting line of the Constitution of India. So Hasrat Mohani proposed that India, instead of being designed as a sovereign democratic republic, be made a union of democratic socialist republic to be called UISR. So, you know, on the pattern of USSR, he wanted to propose the creation of the country like United Union of India. They wanted to create a Union of India, and they wanted to follow the pattern of USSR, because, you know, there is a lots of debate, and you have read several judgments about the structure of the Indian Constitution, that whether it is a unitary constitution or it is a federal constitution. So remember, in the Constituent Assembly also, this was a discussion, because we all are aware that at the time of the independence, India was divided into provinces and the princely states. And there were around 565 princely states. And this option was given to them by the Britishers, that it is up to them that whether they wanted to go with Pakistan, they wanted to go with India, or they want to remain as a separate territory. So obviously, the biggest credit to create this unified India goes to Sardar Patel, because he basically unified all these princely states. And remember, because you know, lots of false statements are also going on, that there was a difference of instrument of accession which was given to rest of the states and to the state of Jammu and Kashmir. No, there was no difference. There was the same instrument of accession, and through the same instrument of accession, there was proper merger. I am using the term merger. The proper merger of all the princely states in the Union of India. So that's why, you know, you will never get any term like federal or federation in the Constitution of India. What Article 1 says? Article 1 says the Bharat, India, that is Bharat, shall be a union of states. So, you know, this idea of USSR, that was not very much workable in the case of Indian Constitution. Then debate on invoking God, because some people were under this impression that the starting line should begin like, you know, when you read the American Constitution, it also begins with "We the people of America." So few were supporting this idea that it should be in the form of "We the people of India." Some were supporting that it should be started in the name of God. Some were saying that it should be started in the name of goddess, and few also suggested that the preamble should start with the name of Mahatma Gandhi. So different members have their different kind of suggestions. So you can very well read it in the slide which I have mentioned here. Now debates on the once we are going to talk about this debate of the preamble. Thirumala Rao argued that it should not be subjected to the vote of a house. the people, whether India wants God or not, I have discussed this already, rejecting pleas by both Prasad and B.R. Ambedkar to drop his amendment, his motion, along with the demand for a division of a vote, and ultimately it was struck down and it was rejected. You can read it on the slide by the margin of 41:68. So the term God, ultimately it was decided that it is not going to be used. Again, I am going to mention a very important part. Very recently on 12th January, we celebrated the birthday of Swami Vivekananda. And most of you perhaps not aware that many times in the Constituent Assembly debate, the thoughts of Swami Vivekananda was discussed and mentioned. He was quoted by the members of the Constituent Assembly debate at many point of time. Here I am just going to mention what Mr. H.V. Kamath has said on 19th November 1949. I would only say one thing more, sir, and that is that we, the people of India, will not forget our spiritual genius and our ancient traditions. Remember, this is very much important, because once we are going to talk about that, what is the speciality of a particular country, then for the country like Britain, parliamentary democracy is their strength. For the country like America, the democracy is the people's democracy is the strength of United States of America. But once you talk about the strength of India, remember the strength of this country is the spiritual democracy. And the meaning of spiritual democracy is nobody is going to impose any faith upon you. It's up to you that how you are going to search your spiritual inclination, how you are going to search and profess your idea of God. So that's why, in the case of India, you will get a different kind of spiritual ideas. And this is the biggest strength of this country, because India is a country which is not united on the basis of religion like Islamic or Christian countries. This is not a country which is united on the basis of the language. Like, the basic reason of the division of Pakistan and Bangladesh, religion wise, they were united, but they were divided because of the language. East Bengal was supporting the idea of Bengali language or Bangla, while the rest of Pakistan was saying no Bangla, but Urdu. So the language was also not able to unite them. So the language cannot unite, the religion cannot unite, and the economic interest. Very recently, we have seen the example of European Union. For the Western country, profit is something which is very much important. European Union was formed to make Europe as a super economic power. But ultimately, what has happened, we have seen there is now European Union has weakened very much. And we have seen that how the country like Britain, they decided to take the option of Brexit. So ultimately, the religion is not able to unite. The language is not able to unite. The economic interests are not able to unite. So the country like India, they are united on the basis of culture. They are united on the basis of spirituality. That's why once you go and travel the country like Nepal, they will say that we are Bharati, but we are not Indian. And what is the reason? Because they follow the same kind of traditions and same type of practices. But yes, geographically, they are a different country. So that is also a difference between cultural nationalism and the definition of the modern state. So here he is saying that, that's why he is saying that Vivekananda, who said that the day of India forgets God, the day she discards spirituality, the day she will die. That day she will cease to be forcing the world. I hope we will keep alive our tradition in spite of the fact that we lightheartedly forgot to invoke the name of God in the preamble. Let us keep the world constitution in the spirit of divine guidance, under divine grace and blessings. Swami Vivekananda exhorted India to rise and chant the Vedantic mantra, awake, arise and stop, not till the goal is reached. So, once we are going to talk about the Indianization, most of the time, the things which has been accepted, we pay more, focus upon that. But we should not forget that in the case of the Indian Constitution, those whose proposal were rejected, they were equally important, and they were also the part of the Constituent Assembly debate. So idea of spirituality is the idea of India. And once we are going to talk about the Indianization of law, we should not forget that Indianization means the spirit of the Indian Constitution, and the spirit lies in the spirituality. So again, there was, I am just quickly going to wrap up all these slides because very little time is left. So Gandhi and the preamble, Brajeshwar Prasad opposed, is also supported. You can read all these things. I will also share subsequently. Debate on the preamble. One very important aspect, because there is a lots of discussion about keeping the term secularism. So the idea was secularism was also discussed in the Constituent Assembly of India, but that was not accepted. So in the original constitution, term secularism and socialist both were not there. So what is why they did not kept that particular term secularism in the original constitution, and what is the exactly meaning of the secularism? Secularism is a term which is basically coined in the European country. And how basically this term was coined and how it is not fit for India. I'm just going to quickly brief up the things, and you can read whatever is mentioned on the slide. The important point of the secularism is, in the case of Britain, there was a long conflict between the church and the king. And the reason of the conflict was who is superior. So sometimes the churches try to impose their power over the king, and sometimes king tried to impose their power over the churches. And after a long battle, you can say, in a way, the churches get confined in a particular territory, which is presently known in the name of Vatican City. So ultimately, there was a compromise in the European country, or in among the Roman Empire. And what was the terms of the compromise? The term of the compromise is, the churches will not interfere in the domain of the king, and the king will not interfere in the domain of the church. So the church will exclusively perform the religious activity, and the governance will be exclusively in the hands of the king. So there will be a separation of church and the king, and that is the idea of secularism. Neither the state will interfere in the functioning of the church, nor the church will interfere in the functioning of the state. But remember, here in the case of India, the idea of religion is entirely different, because here in India, we follow the idea of dharma, and dharma is basically not religion. Dharma is something which is basically related with righteousness. So, once we are going to compare the model of West to the model of India, in the Western model, they try to institutionalize morality in the form of different kind of institutions. But in the case of India, we try to, socialize the morality among the people. So we never believed in so much institutionalization that like there should be a police system to enforce everything. There should be a judicial system to enforce anything. There they used to believe a lot on the institutionalization, but here the people were guided by the principle of dharma, and dharma means what is righteousness and what is morality. And this is the reason that in the original constitution, they did not accepted the idea of keeping the provision of secularism in the original constitution. It did not, because that's why, even in the present circumstances, we say that India is not a religionless state, but it is a country where the state is not going to promote any religion. That is the meaning of spirituality, and that is the meaning of secularism in context to India. But it is very much clear that the translation of secularism is not dharma nirpeksh, but it is a panth nirpeksh, because you cannot be nirpeksh to the dharma. Dharma is something which is going to guide everybody, each of us, about our righteous conduct. So secular term was basically subsequently added in through 42nd Amendment Act 1976, and now so much of discussion is again going on over adding this term and the way it has been perceived by the political parties or the common masses. And one very important interesting point is that secular term was added by the assembly, whose term was extended by 1 year. You all are aware that when Mrs. Gandhi was the Prime Minister, Allahabad High Court has declared her election as invalid, and Allahabad High Court ordered her that till the time her appeal is pending, she cannot take any important decision, and also stopped her from visiting Parliament. So she imposed emergency on the ground of internal emergency, and the life of Lok Sabha was extended for 1 year. Though we all are aware that even the cabinet ministers of a government, they were not aware that she is going to impose this presidential rule of the national emergency. So she just called the then president, Mr. Fakhruddin Ali Ahmad, and asked him to impose national emergency. National emergency was imposed. And then according to the provisions of the constitution, the life of the Lok Sabha was extended for 1 more year. And in that extended assembly, this 42nd Constitutional Amendment Act 1976 was passed, which is also famously known in the form of a small constitution, because many provisions of the constitution were amended. So this through this 42nd Constitutional Amendment Act, basically the terms socialist and secular were added in the Constitution of India. They were not the part of the original constitution. So debates on of inserting from the people, again you can read all these things. Only 10 minutes left, so I would like to wrap up quickly. Status of preamble. This is again a very important case, because you all are aware about a very famous case. The name of the case is Berubari Union. And in the case of Berubari Union, it was held because Berubari Union is basically related with exchange of enclaves between India and Pakistan. At that point of time, Bangladesh, which was then known in the form of East Bengal, that was the part of the Pakistan. So this Berubari Union is basically a case which is related with the exchange of enclaves of Cooch Behar and division of Berubari Union, where the then Prime Minister has decided to give half of the portion of Berubari to the Pakistan. So in this case, the issue was raised that we, the people of India, the sovereignty lies among the people of India as per the preamble of the Indian Constitution, and the people of India does not want to hand over half of the portion of Berubari Union to Pakistan. And in that case, the Supreme Court has held in the case of Berubari Union that preamble is not the part of the Indian Constitution. But subsequently, in the case of Keshwanand Bharati, the Supreme Court has admitted that preamble is a part of the Indian Constitution. And what was the reason of this, this major shift from Berubari case to Keshwanand Bharati case? The reason is, in the case of Keshwanand Bharati, this thing was brought to the knowledge of the Supreme Court that, like rest of the provisions of the Indian Constitution, the preamble of the Indian Constitution was also adopted by the Constituent Assembly. So like rest of the provision, the preamble was also adopted. So like any other provision of the Constitution of India, preamble is also the part of the Indian Constitution. So in the case of Keshwanand Bharati, it was held by the Supreme Court that preamble is the part of the Indian Constitution. So there was, in a way, there is a shift. Now, I wanted to draw your attention towards a name which is very famous, but which is very important, but not very famous. His role is very much largely, unacknowledged. Mr. B.N. Rao, Benegal Narasimha Rao. He was appointed as the constitutional advisor to the Constituent Assembly by Lord Webble. So, he played a very instrumental role in the making of the Constitution. And as part of his research in drafting the Constitution of India, Mr. Rao has visited several countries. And the Chief Justice of American Supreme Court, Mr. Felix Frankfurter, he told him that he should not keep the term due process in the Indian Constitution. Under Article 21, as I discussed few minutes earlier, that in the original Constitution, the term used was procedure established by law. So this suggestion was given by the American Supreme Court Justice Felix to Mr. B.N. Rao to avoid, any kind of undue burden which could be put upon the judiciary. So it was Mr. B.N. Rao who was the advisor of the Constituent Assembly, and actually what he used to do, he studied the constitution of the different countries, he selected the provisions which were more suitable to the to then India or to India, and then he used to give those provisions to the drafting committee. Then the first deliberation used to be made by the drafting committee, and after the deliberation, the drafting committee used to decide that whether the provision should be kept in the same form or it should be modified. Then after deciding the things, they used to put it before the Constituent Assembly, and there the Constituent Assembly used to finalize the thing. But the important point is the contribution of Mr. B.N. Rao was not very much acknowledged, and I am very much sure that even most of you have not heard his name also. So he declined to accept any kind of remuneration for his work as a constitutional advisor. But yes, in the last speech of Constituent Assembly debate, Dr. Ambedkar has said in his concluding remark that the largest credit of making this constitution goes to Mr. B.N. Rao. So it was Dr. Ambedkar who has actually acknowledged the contribution of Mr. Benegal Narasimha Rao, because he was also, along with Dr. Ambedkar, he was also one of the key architecture of the Indian Constitution. Now, Dr. Ambedkar's last speech, this is something which is very much important, and you can see that what kind of great vision Dr. Ambedkar was having, and whatever he has stated in his last speech, that is presently much more relevant than ever before. So he has given his last speech in Constituent Assembly on 25th November 1949. So what he's saying, what perturbs me greatly is the fact that not only India has once lost her independence, but she lost it by the infidelity and treachery of some of her own people. So, he has given the example of Jaichand. He has given several examples where the treachery of Indian was the main cause that India could not protect its, independence for so long. So he is just showing his concerns. This is his statement, which I am quoting here. This anxiety is deepened by the realization of the fact that in addition to our old endangered form of caste and creed, we are going to have many political parties. What exactly he is trying to say, because presently we are seeing this problem, that there are different kind of regional parties which are in the power in different states. So, he is basically going to warn about those things. What he is saying that if the regional political parties are going to become more powerful and their regional interests are going to be more dominating, then in that circumstances, it will be very difficult to protect the independence of India for so long. And now it is happening, and we can very well see that the regional parties, they are not very much interested in the cooperative federalism, and we have seen very many examples like how they are going to influence the international relationship. You can take the example of distribution of Teesta water dispute, where the state of West Bengal is saying that we are not going to abide this treaty which has been done between the Bangladesh government and the government of India. And Mamata Banerjee, the chief minister of Bengal, she is saying that I am not ready to share my water with Bangladesh. So one chief minister is going to influence the foreign policy. Very soon we have seen the security breach of prime minister in the state of Punjab. And so many things are going on. So what he is warning about, he is saying if the regional political parties are more interested in their political interests instead of being interested in the interests of the nation, then in that circumstances, definitely the independence of this country is going to be jeopardized. And next he is saying we have constitutional method, because we have seen so many demonstrations recently in the form of agitation, or earlier there was Shaheen Bagh case. So what he is saying, this method of revolution is not good. So if the constitution is going to provide you a mechanism to resolve the issue, then in that circumstances, civil disobedience, non-cooperation and satyagraha, these things should be abandoned. Because if you have any grievances towards in any kind of decision of the government or the government scheme or the policies, then in that circumstances, it is better to approach to the court for the remedy instead of using any of these methods. So this is also because, now again, it is a very great debate that if the parliament is going to make any legislation and the people are, they are protesting as we have seen in the case of farm laws, then in that circumstances, what would be the solution? Because here the problem is they are saying that they have no faith in the government and they have no faith in the judiciary also. So it is a very big challenge that how the system will work. And perhaps this thing was seen by Dr. Ambedkar, and that's why he, in his last speech, he has warned about that. And then at the end, he's saying we must make our political democracy a social democracy also. This is something which is very much important. Because India was a country which used to believe in the idea of social democracy. So that's why if you read Rabindranath Tagore ji, he is not very much happy about this idea that the government should perform each and every function. That's why when the British government started doing, they tried to, doing many things or controlling many things in the state of West Bengal. In the state of Bengal, Rabindranath Tagore is opposing that idea because he says that the social democracy should be more strong. And the meaning of social democracy means the decision in which the interest of the local people is involved should be taken by the society itself. Now, what is happening for every big and small thing, we are dependent upon the government. So the concept of the social democracy is diluting like anything. So in a diversified country like India, where the social democracy is going to be diluted, this is something which is not a very good idea. But we can say that through the Panchayati Raj Act, basically up to a certain extent, we have not only tried to decentralize the power of the government, but we have also tried to protect the idea of social democracy. So present debate, so many things are going on. Indic viewpoint of Indian Constitution. Because, this is again a very much important, very, very important thing. Suppose there is one term equality. How we are going to interpret the idea of equality? How we are going to interpret the idea of democracy, the idea of secularism, the idea of, a republic, the idea of equality, idea of freedom, idea of liberty. So, the important thing is the terms in India and America, in Europe or in some other country, they may be same, but they take their meaning, they evolve their jurisprudence on the basis of their own culture and tradition. So that is the basic meaning of Indianization. So Indic viewpoint about a particular, terminology that plays a very, very important role. Personally, I believe the biggest mistake which was made by us, we have not only adopted foreign laws and, foreign provisions, but we have also borrowed foreign interpretation. So most of the time that is not suitable. And why that is not suitable? Because the conscience of the people or the will of the people is somewhere else. And the interpretation which is going to be imposed by the court, that is somewhere else. So we are not able to create a match between both of them. And that is the reason many times it backfires. So the decision which is going to be pronounced by the court, that should be based upon our own jurisprudence and our own philosophy, our own culture and our own tradition. If something is good, then definitely we should accept it, but we should not believe that whatever we are having, that is bad. So that is something, which is not a good psychology. The difference between Bharat and India, again, a new debate has been started. And, during the Constituent Assembly debate also, this issue was raised that what should be the name of independent India? It should be Bharat, it should be India, it should be Hindustan. What then ultimately they decided India, that is Bharat, shall be a union of a state. So this country is unique in two ways. In one way, at least we can say that it is having two names, Bharat and India both. But once you are going to interpret the idea of Bharat and idea of India, they are in quite contrast. So that's why in the present day, through the judicial pronouncements also, judiciary has evolved two types of jurisprudence, the urban jurisprudence and the rural jurisprudence. And the rural jurisprudence is the idea of Bharat and the urban jurisprudence is the idea of India. But fortunately or unfortunately, many times we are trying to impose the jurisprudence of India over the jurisprudence of Bharat. So we need to maintain a balance. Indian secularism, I have told these things in my earlier slides. The democracy, I think democracy is a debatable issue, not only in India, but in the entire world. The reason is democracy plays on number. So sometimes this is also a very dangerous, perception. Why I'm saying it's dangerous? Because the person who is highly devoted, highly committed, highly intelligent, the value of his vote is 1. The person who is highly selfish, highly anti-national, highly depressive, and highly greedy, the value of his vote is 1. So, we are going to create same value for two kind of voters who are totally contrast to each other. But at the end of the day, the number is going to win, not necessarily who is right that is going to win. So that's why I think, because we have seen whatever has happened in the case of United States of America, when Mr. Donald Trump was contesting the presidential election, and that was also a dance of democracy. And we have seen several such things in the case of India and the different parts of the world also. So this democracy which plays on the number, it basically divides the people. Democracy should be more inclusive. And once you are going to make a deep analysis of, Indian monarchy and the present day democracy, then many times you will find that Indian monarchy was much more democratic than the present day democracy, which believes in divide and rule, and which plays on the basis of the number. The fundamental duties, again, it is very much important, and this is more important than any other thing, I believe, because the basic difference between the mistake which we made. Personally, I believe rights are definitely important, but remember, in the Indian society, once you are going to read the entire history, Indian society was always more inclined towards duties. The Western world, they were not receiving their rights, so they were more inclined about their rights. You just go and check the revolution which has happened in the Western world. Most of the revolutions were just for the sake of rights. So they gave more importance to the rights. But unfortunately, when we adopted this constitution, we gave again more and more importance to the fundamental rights, and the fundamental duties received the least importance, importance in the Indian constitution. But now we can see that we are seeing the effect, that if the society or the people are not bothered about their duties, then the country is, at least the idea of governance is not going to be implemented very successfully, because we believe that the governance means the role of the legislature, the role of the judiciary, and role of the government. But believe me, in the case of governance, the role of the citizen is extremely important. But unfortunately, in our entire discussion, the role of an individual in the governance is least discussed. So without the involvement of the citizen, the model of the good governance can never be implemented. And that's why the fundamental duties becomes extremely relevant. Yes, then the pictures used in the original constitution. I just show you one picture of the original constitution. Oh, my PPT stopped working, I think. Okay, so the present interpretation, again, it is very much important. Yes, this is the original constitution. So original constitution, on one page, there is Harappa civilization, which was one of the most modern civilization of the world. So this is the original constitution about which I'm talking, that you should keep it in your library. And this is a picture of fundamental rights, where Rama is coming back to Ayodhya with Lakshman and Sita. And then from the different pages, you will get different kind of pictures, like Gautam Buddha is there, Rani Lakshmibai is there, Nataraj is there, Krishna, Krishna and Arjuna from Kurukshetra is there. So, basically and on this original constitution, each and every member of the Constituent Assembly has put his signature. So this is our cultural and philosophical heritage. So in a way, basically, they wanted to give this indication that the constitution cannot be understood without understanding your own philosophy, your own culture, your own history, and your own tradition. So unless and until you are going to create a fusion of both the things, you can never understand constitution in the true sense. So once we are going to talk about the Indianization, and we are also receiving several kind of criticism, I think this original pictures from the original constitution are self-explanatory about the idea of India. So I think I have taken enough time. that's on my part. And with this, I just close my presentation. Thank you so much for the patience listening.
Thank you so much, ma'am, for your enlightening words. It was highly informative and very interesting to hear about the history of Indian Constitution and its preamble. Now, I would like to ask if anyone has any questions to ask. Any
I
questions?
don't think there's any question.
Oh, there is one question which could be there in chat box. I could read that.
Yes, ma'am.
Kanji.
Yes, I'll read. How can we say that protesting against government is dangerous thing for us? If government not listening the voice demands of people, then what to do? If former CJI Ranjan Gogoi publicly said that I don't have faith in Supreme Court and not get right justice, then how could common people of India believe in our judicial system?
Then we should try to develop a new kind of system, because what is the meaning of democracy? You are going to cast your vote in the favor of a particular government, and the largest political party is going to form the government. They have made certain legislations. You may be agree, you may not be agree. That is another thing. But if you are disagree, then what Dr. Ambedkar says, that a mechanism has already been provided there. And what is the mechanism? Firstly, you should exercise your remedy, which is available under the constitutional scheme. So, you should approach to the court, you should fight for your case, and you should, whether then you can be happy, you can be unhappy. But obviously, in every case, if the people are going to demonstrate, especially in these ways through which these things are happening in last many years, this is a very dangerous precedent as per me. Because if few lakh people are on the road, they are going to pressurize the government to do something which they do not like. But here is a lesson for the government also. I put a very important point, maybe that was not heard properly by all of you, because Dr. Ambedkar is also going to talk about one more thing, and that is the social governance. So the meaning of the social governance is there should be a participatory governance on the part of the people also. So once the government is going to introduce something, then obviously there should be a very healthy discussion with the stakeholders. So there is one part which is missing these days on the part of the government. Sometimes they always invite, the suggestions from the stakeholders, but there should be a proper, discussion with the stakeholders, and then the government should come up with a policy. Otherwise, whatever the legislation the government is going to form, either this legislation or those legislation, one segment of the people is unhappy. So if they came up on the road and they started protesting, then in that circumstances, the concept of the democracy is going to be diluted like anything. Because suppose more number of the people are in the support of that, and if they come on the roads, then what will happen? We are going to create a very chaotic situation. That's why these types of things should not be entertained, should not be encouraged. If you have any objection, then in the democracy, firstly, you should go and approach the court. And whatever Justice Gogoi has said, that may be his personal opinion. And I think a strong, this is a high time to reform the judiciary as well. Because whatever they say, only once they complete their term. Whenever they are holding the position of the judges, why they are not trying to improve the things, within the judiciary? Whenever they come out, they give some or other kind of statements which they never say, or which they never encourage once they are holding the office of the judgeship. So I think that may be his personal opinion, but yes, maintaining the integrity and the neutrality of the judiciary, that is also the responsibility of the judiciary. And that's why once I'm going to raise this question about the fundamental duties, these fundamental duties must be compulsory for each and every citizen, including every person holding any kind of constitutional position. The biggest problem this world is facing these days is we are not bothered about our roles which are prescribed to us. So because we are not honest on our part, a chaotic situation has been created. So that is a problematic thing. Any other
Ma'am, I have a
Thank you,
question.
ma'am.
Ma'am,
I
I have
have
one.
a petition and request to Principal Dr. Smita Vaidya ma'am. So please conduct one more session with Seema ma'am. It is really very informative now. Thank you, ma'am. Thank you, Principal ma'am.
Yes, yes, definitely.
Ma'am, I have one question. May I ask?
Yes.
Seema ma'am, in the last few minutes, you talked about the political democracy and the social democracy. What will be the what is your thought on the youth changing the how can youth of this country contribute or get motivated to change the system from the political democracy to the social democracy? Thank you.
That is all about taking more and more responsibilities. Actually, in independent India, personally, I believe that there is a lots of problem. And the biggest problem is, as a citizen, what is our responsibility? We don't know. I'm telling you a very live example of my experience. One day I was delivering a lecture in CPDHE, and I asked teachers that what is the purpose of education which you are teaching to the students. They have no idea for what they are going to teach students. I ask the same questions to my students कि आप किस लिए पढ़ रहे हो? पढ़ने वाले को ये नहीं पता कि उसको पढ़ के क्या मिलना है. पढ़ने वाले को ये नहीं पता कि वो किस लिए पढ़ा रहा है. पढ़ाने वाला पढ़ा रहा है और पढ़ने वाला पढ़ रहा है. So you can just imagine that we are not going to land up anywhere because we have no clarity that what exactly we want. So agar even if you are a topper of your batch, there is no guarantee that you are going to get a good job. So if the education is not able to give an employment, guaranteed employment to you, आप 25 साल आप खर्च करते हो और 25 साल खर्च करके आपको एजुकेशन के बाद लगता है अब आप नौकरी ढूंढ रहे हो. You are not able to, that is not going to give you any guarantee of employment. आपका कैरेक्टर बिल्डिंग नहीं हो रहा है, आपका नेशन बिल्डिंग नहीं हो रहा है, आप को नहीं बिल्ड कर पा रहे हो. आप अपनी लाइफ को कैसे लीड करते हैं, हाउ टू लर्न टू लिव अ लाइफ, दिस इज ऑल्सो नॉट द पार्ट ऑफ आवर क्यूरिकुलम. तो मुझे तो ये नहीं समझ में आता कि एक्चुअली में हम पढ़ा क्या रहे हैं. एंड आई थिंक अ वेरी सीरियस डिस्कशन ओवर दिस क्वेश्चन इज एक्चुअली रिक्वायर्ड. Neither nation building, not personality building, neither character building, कुछ भी हम नहीं कर रहे हैं. तो उसके सिर्फ हम क्या कर रहे हैं, we are trying to create a kind of mentality where we want much more, we want to create much more desire than we deserve. तो ये जो हमने desire और deserve का gap create किया ना, this is the biggest problem for every individual. जो भी LLB किया हुआ है, या तो उसको वो बनना है, पालकी वाला बनना है, और या फिर वो एकदम सुप्रीम कोर्ट का जज बनेगा चीफ, पर उसकी वो कैपेसिटी है कि नहीं है. तो यहाँ पे क्या हो रहा है, यहाँ पे हमारे पास कोई मैकेनिज्म नहीं है टू आइडेंटिफाई द स्ट्रेंथ ऑफ द स्टूडेंट. और उसके कारण क्या हो रहा है, जो हमने गैप पैदा किया है, एवरीबडी इज जस्ट फाइटिंग फॉर देयर सर्वाइवल. Once we are going to talk about the social governance means as a citizen and as a society, we are very, very responsible. I'm just going to ask a simple question. आजादी के इतने साल बाद इस देश में स्वच्छ भारत मिशन चल रहा है. क्या ये मिशन चलना चाहिए क्या? Is it not our responsibility that we should keep our surrounding clean? इसके लिए हम करना पड़ता है कि नहीं, मूंगफली का छिलका आपको यहाँ नहीं फेंकना. This is the lack of social governance. Social governance means as an individual, we don't have any realization about our responsibility towards our society, towards our environment, towards our family, towards our nation. What we want, we just want more and more and more. And for what we want, we don't know. Because you take the example of the most developed countries, we are developing a society where the youth believes that earning money is the biggest, biggest achievement of your life. You just go and see what is happening in Japan, where the people are very prosperous. What is happening in UK and USA, where the people are very prosperous. They are dying because of loneliness. Their society is a completely depressed society. और वहां पे अभी आप देखो तो ब्रिटेन में तो यूथ ने एक नया ट्रेंड शुरू किया है. एक बहुत एज्ड आदमी से और कोई यूथ लड़का या लड़की जा करके 2 घंटे बात करते हैं और उसके लिए वो चार्ज करते हैं. हाईएस्ट नंबर ऑफ सुसाइड्स इन द कंट्री लाइक जापान, जिसकी कि आपकी जीडीपी इतनी हाई है। तो हम क्या कर रहे हैं ना, वी आर नॉट एबल टू मेंटेन अ बैलेंस। बैलेंस किस चीज में, कि हमें क्या चाहिए, व्हाट इज द मीनिंग ऑफ द कंप्लीट लाइफ। दैट्स व्हाई पर्सनली आई बिलीव कि वी आर अ कंप्लीटली डीरेल्ड सोसाइटी एंड वी डोंट हैव एनी रियलाइजेशन कि हमें अपने से क्या चाहिए, अपनी लाइफ के लिए क्या चाहिए, व्हाट इज द मीनिंग ऑफ लाइफ एंड व्हाट इज द पर्पस ऑफ लाइफ। एंड दैट्स व्हाई वी आर ओनली क्रिएटिंग अ डिमांडिंग सोसाइटी व्हिच इज ओनली राइट सेंट्रिक एंड व्हिच इज लीस्ट बॉदर अबाउट देयर ड्यूटीज। So if you are going to create such kind of society, if you are going to create youth which is purely right centric, then in that circumstances definitely they have no sense of their social responsibility. So social responsibility is more governed, you know, through your morality and through the ethics of the society, जहाँ पे आपको पता है कि आपका दूसरे के प्रति, अपने देश के प्रति, अपने समाज के प्रति आपका क्या कर्तव्य होता है। And remember, we are passing more and more legislation. We are talking about giving more and more rights. But ideally, I am telling you, none of us are going to enjoy these rights because we have no respect for our duty. So that is the reality. And that is the difference between what we deserve and what we desire. So I think a balance should be maintained between both of them. I think I got your answer, though this is a very, you know, it takes more, it requires more time. So some other day we will discuss over these questions.
Thank you so much, ma'am. Should we take more questions?
I can take only one more question because I have a meeting from 1 p.m.
Okay, ma'am.
Any one question.
Many judgment and case laws say basic structure, doctrine, ethos, and fabric of constitution cannot be changed. How is this being used as tool by many in today's structure of democracy?
Basic structure of the democracy is something which is not a very new idea. You know, basic is something which is the part of somebody's personality, your basic nature, your basic trait, the structure, certain basic characteristic of a particular society, a particular you know, tradition or a particular culture. And in the similar way, the constitution also have a basic structure which basically, you know, that is never going to be altered. So even if this thing was not going to be declared by the Supreme Court, then too it is implied. Like I would like to give you one example, the right to privacy. When the right to privacy judgment was passed by the Supreme Court, there was a lots of celebration if privacy has been declared as a fundamental right. Even if privacy was not declared as a fundamental right, then too it was a part of right to life. When animal prefers their privacy. So if you are a human being, if you are enjoying your right to life, then right to privacy is the part of that. So, you know, the society, the constitution can never run without certain fundamentals. And the same thing is applicable in the case of Constitution of India also. Even in the case of Keshwanand Bharati, the Supreme Court has given certain illustrations. And they said that this list is not exhaustive. So some more things can be added. So if some more things can be added, then certain things can be removed also. So fundamental, what is the fundamental need and what is the fundamental for a constitution, that can be decided, you know, by the Supreme Court. Or Supreme Court की जब हम बात करते हैं, again I am repeating, what is the collective conscience of the people, that is a very important thing to decide that what is fundamental. You know, because these days a very important term which is celebrated a lot, and that is the constitutional morality. What do you mean by constitutional morality? Can the judges impose their morality in the name of constitutional morality? Constitutional morality means the collective conscience of the people of this country. But what is going on? Kabhi main isko discuss karungi. What is going on in the name of the constitutional morality? Certain things are good, but certain things are not good. If you just see, I will just like to give you an example. Maybe many of you would like it, many of you would not like it. Marriage was a very important sacrament in the Indian society. But through the judicial pronouncement in the name of the constitutional morality, the judgments are talking about sexual liberty in matrimonial home. Is it possible? What you are talking about? Sexual liberty in matrimonial home, is it possible? So, you know, what kind of morality is this? In any Indian society, can you accept this? Can you imagine this, that the people are going to talk about sexual liberty in the matrimonial home? So these things are also done in the name of the constitutional morality. So the important thing is few people are going to decide the constitutional morality of this country, but who are those people? Are they representing the collective conscience of the people? I think this is a high time to discuss all these things, and that's why the procedure of appointment of the judges, it should definitely be discussed. Unless and until we are going to, you have a certain eligibility, it's not about having a eligibility, it is all about having a characteristic. कि मैंने 10 साल practice कर ली या 5 साल 10 साल judge रह गए, then I am able to be elevated in the Supreme Court. That cannot be a criteria of my selection as a judge of the High Court or the Supreme Court. We need to evolve some more comprehensive model, and that's why unfortunately still when we talk about the cognitive intelligence, we talk about only the IQ. But I personally believe once you are going to talk about the cognitive intelligence, it does not include only your intelligence quotient. It also includes your spiritual, social, moral and environmental quotient. It should be a complete, you should be a complete person, specifically once you are going to hold such office. So that's why the judiciary should think very seriously why the people are losing their faith in judiciary. And it is a very high time. The same judiciary talks about the right to freedom of speech and expression, but when the judges are trolled, they say that the people are trolling me. Trolling is not a freedom of speech and expression. That is also freedom of speech and expression. So what is the important thing? The important thing is the people of this country should realize, and the entire world should realize, that every right comes with this responsibility. If I have right to freedom of speech and expression, then I should also know that what I should speak and what I should not. The problem is the Constitution teaches us that we have a right to freedom of speech and expression, but there is no formula to guide us that what we should not speak. Though there are certain restrictions, but there are so much discussion is also going on. But I will just conclude with a simple observation, which I am going to leave upon all of you, that 19(1)(a) comes with 19 subclause 2. 19 subclause 2 is also the part of the Constitution. So if 19 subclause 2 is there and it is not going to be removed by the Parliament, whether the judiciary on its own can remove any of the restrictions which are prescribed under Article 19 subclause 2. And if they are going to do it without the intervention of the legislature, are they not going to violate the doctrine of separation of power? So you think yourself, you apply your mind, and I again say somebody has asked a question about Justice Gogoi. So I think it is a very high time for the judiciary to contemplate the way they are performing and the way they are functioning and the way they are going to appoint themselves, because this is a high time and the judiciary should seriously think about their accountability also and transparency also. I think I have given my answer.
Thank you so much, ma'am, for explaining us so well. And thank you all the students and participants for their overwhelming response and appreciations. But due to time restraint, we have to now move forward. And as we come to the end of our webinar, I would like to invite Assistant Professor and our coordinator of the webinar, national level webinar series, Dr. Srinath Panchabhai sir, to give the vote of thanks.
Thank you, Ria. Well, what to say, more than 120 thank you messages are already there for Dr. Seema Madam in the chat box. The strength has been gone to 210, 220 in this Zoom meeting. Plus, there were a lot of viewers in YouTube as well. But still, I'll take an absolute honor and privilege to propose vote of thanks today in this national webinar number 12 on history of the preamble and contemporary debates. This was before I am thanking to Seema Madam. First of all, I thank to my own principal, Dr. Asmita Vaidya Madam, because already when I forwarded the messages to the different participants, they have quoted that it is one of the finest and wonderful topic, and therefore today we see that number of strength is been increased. Well, in this national webinar, we have Dr. Seema Singh Madam, Assistant Professor, Campus Law Center, Delhi University, as our keynote speaker today. Dear participants, today we have heard one of the finest commentary on the preamble of the Indian Constitution. And I think you all will agree that the interpretations, connotations, and the facets which Dr. Seema Madam discussed with us today about the preamble and the contemporary debates were wonderful. Madam, from the bottom of my heart, I'm thankful to you, because not only the participants, but each and every one of us is getting benefited by your interpretations and commentary on the history of the preamble and contemporary debates. Especially, I have got the message that those last moments of your clips when you were discussing about Dr. Ambedkar's last speech on 25th of November 1949 and your commentary on that. And moreover, you have suggested for our college some pictures, original pictures. Those were all loved by one and all. So thank you very much, madam, for your keynote address and your suggestions. Then I am thankful to the principal of my college, Dr. Asmita Vaidya madam, because of her determined vision and efforts. This Azadi 75 program and this lectures webinar series is been going on viral with not only in India but from abroad now. We are getting the messages that within such a small span of time, we are discussing so much facets of the law, which are not only benefiting to our own students but overall participants. So thank you very much, madam, for initiating Azadi 75 and this webinar series. Then I am thankful to all my teaching and non-teaching staff of Government Law College, especially the students who have taken keen interest, and they are appreciating and they are working for the smooth working of this webinar series. Thank you very much, dear students and teaching and non-teaching staff. Last but not the least, I'm thankful to all the participants. Today's strength and their comments in the chat box reflects that this webinar was a very successful one. And I wish that your good wishes will always remain with the Government Law College. Tomorrow and day after tomorrow also will continue with some different facets of law. So do remain present tomorrow and day after tomorrow. Today evening or tomorrow morning, I'll send the link. Thank you very much, all of you. Over to you, Ria.
Thank you so much, sir. I now request everyone to switch on their video cameras for a photograph. Harshal, please take a screenshot.
किती message येऊन राहिले रे आजचं?
Is a screenshot taken?
Yes.
Okay. Now I would like to thank our principal, Dr. Asmita Vaidya, and our professor, Dr. Srinam Panchabhai sir, for all your efforts. I would also like to thank Harshal and Ketaun for giving me this opportunity to host. Before we end, I would request everyone to kindly rise for the national anthem. Thank you so much, everyone, for joining
Thank you
us.
so
It
much.
was
Thank you,
wonderful.
Vedya ma'am. Thank you so
Yes,
much.
yes. It was wonderful session, and I'll definitely see that you will again come to deliver the lecture in my
Sure,
college.
ma'am. Actually, I have a meeting from one. Otherwise, I would love to take more questions, but unfortunately, not possible this time. Next
Yes.
time, definitely, we'll try to plan in such a way where I could interact more.
Yes, and special thanks to Gaddapar sir, because he has suggested your name, and so we got opportunity to call you over here. Thank you.
Thank you. Thank you so much. Thank you.
Thank you so much, ma'am. Thank you, everyone, for joining us today. We may now end the webinar.